open.
Well, thanks for coming, everybody. So for the next, I don't know, what did you say, 2 hours? We're going to talk about an issue that's certainly been important on campus recently, but I think is particularly important because it relates in fundamental ways to what we do as a university. The First Amendment, I think as you know, is often viewed as kind of the gold standard of speech protection. The United States First Amendment is the most speech protective legal regime in the world. And universities have often, although not always, sought to uphold similar principles. What we're going to talk about, I think we agreed for about the next half an hour or so, 40 minutes or so, is lay out some principles in terms of how to understand the scope of the First Amendment, what it covers, what it doesn't cover, how principles about free expression apply, particularly in the context of a university, including private universities like this one, which are not technically bound by the First Amendment, but which nonetheless aspire to adhere to such principles. And then talk about how protest interfaces with that, because protest often involves conduct that might not itself be strictly First Amendment protected. And then maybe say a little bit about existing policies, and then open it up for questions and discussion. I think that's our plan, right? So let me say a little bit about why some of this is important as a general matter, and then we'll be saying a little bit more about why it's important for universities in particular. The First Amendment isn't first because it was supposed to be the most important. As my con law students learned, the First Amendment was actually drafted as the Third Amendment of the Bill of Rights. It just happened to be the first one that was adopted. The other two were lost to history, although one was later ratified. But the speech and press protect portions of the First Amendment are often seen as particularly important because of their role for self-government, for the ability to speak truth to power, to make claims and make arguments that those in power, the government, but not exclusively the government, wish to express. And was understood, certainly at the time of the nation's founding, as above all else, barring prior restraint. That is to say, there might be certain forms of speech that can be punished or sanctioned after the fact, but that it is particularly impermissible for the government to restrain them in advance, and that it can't serve its role in facilitating self-government if speech can never be heard in the first place. Over time, it has been understood to embrace a broader range of principles. Self-government, not merely in terms of self-government as the polity, but as collective self-government, but also as a means of self-actualization and self-expression, and being fundamental to individuals being able to be a part of a society in which they are free and responsible individuals. And that aspect of the First Amendment is largely what we've understood it to be today, certainly the way it is understood in the legal system. And then in the university setting, and we'll say more about this in a second, similar principles have been recognized as being particularly important because of the university's core functions of seeking truth and providing education. And that openness to ideas and the ability to express ideas are integral to those functions, such that those functions cannot properly occur if those principles are not respected. So that's just some initial background. Bryan's gonna talk through some doctrine, and then I'll have a bunch of stuff to add. So I'll turn it over to Bryan.
Thank you, John. Yeah, and sort of picking up where John left off, this notion that what the First Amendment seeks to do, and its unique role within university setting and environment, raises the tensions that we're experiencing today, our university and other universities across the country, is that how do you abide by, how do you stand for those First Amendment ideals that Jonathan just talked about, while at the same time holding firm to the belief that everyone belongs to this environment, have the right to express themselves and to be able to be a part of this environment without some types of harms, and to allow them to be a part of this this environment, this place where it is particularly important that exchange of ideas, that training through exposure of different ideas is paramount and is the core mission and purpose of the university. Just to get some doctrine underneath ourselves under our feet before we move forward more deeply. Just the fundamental first principles, right? Congress shall make no law respecting the establishment of a religion, prohibiting the free exercise thereof, et cetera, et cetera, et cetera. These freedoms seem to be fundamental, of course, right? And John said, once again, this is not the First Amendment because it was the first one that was made, or most important. It's the Third Amendment. But here we have it. And explicitly it refers to Congress. So it doesn't apply to private actors. It doesn't apply to states, right? It applies to states through the Due Process Clause of the 14th Amendment, and that was established in 1925 in the case Gitlow versus New York. There are forms of unprotected speech, right? There are certain forms of speech that are not protected, despite the fact that we have this broad category, this speech as speech, right? That's not protected. We won't discuss these principles so much, these concepts so much, because they're not directly involved in some of the overall things that we're talking about. Things like obscenity, certain forms of fraud, not all fraud, but certain forms of fraud, like perjury, is not protected speech, right? Communication towards like defamation, libel, slander, infliction of emotional distress, negligent or intentional, right? Those are the types of speech that remains unprotected, right? There's also importance to realize or recognize that too. Once again, a central part of the university setting is academic freedom, as well as our mission to ensure that not just faculty and staff, but students are able to be and have the ability to engage in a robust exchange of ideas. And so what you typically see at private institutions are those missions and those goals expressed through their policy statements, through their mission statements, through their rules and regulations that apply to faculty, staff, and students. So the regulation of speech in private institutions such as ours doesn't take the form so much as it would in a public space, but takes the form of contract law, right? And so we look at and can look to issues of promise, offer acceptance, etc., as a form of contract, and that's embodied. I should say those speech and free expression and ideas, exchange of ideas, are embodied in the mission statement, right? And it's also important to remember that there's a distinction, of course, between speech and conduct. Right? Certain conduct can be prescribed, whether privately or public university or just publicly, specifically, right? I can say, give me your money, right? But if I point a gun at you and say, give me your money, that's a whole different animal. And that's the type of speech or speech plus conduct that can be prescribed, just for example, right? And I just talked about, that's one type of unprotected speech. The others are broadly categorized that been established by Supreme Court precedent. This notion of clear and present danger. These cases that articulated this principle of this type of unprotected speech specifically were articulated, argued, or decided in the context of war and international conflict. So the doctrine that attends clear and present danger cases and principles such as Schenck and Abrams and Dennis versus United States, Whitney, Gitlow even. Typically, they're looking at this in the shadow of laws that were made or created or at least applied in the context of war, context of fear, of the Red Scare, et cetera, et cetera. So that's just one type of unprotected speech that constitutes words that are used, circumstances that are such a nature to give a clear and present danger of a harm or evil. Fighting words is another category of speech that was famously articulated in Czaplinski versus New Hampshire, and the definition is there: those which by their very utterance inflict injury or tend to incite immediate breach of the peace. Now, what's unique about Czaplinski, there's two things. First thing is that what Czaplinski makes clear, though, we can imagine and think of words that somebody might say to us, right, that would make us want to fight them, right, make us want to throw hands, if you will. And that's what happened in Czaplinski. But what's unique is that, and people miss the point of fighting words, is that typically they have to be directed toward a person. They can't be generalized words that one says. That speech has to be directed at a particular person. And then there's the other clause of Czaplinski that talks about the words that are by their very utterance inflict injury. And we can imagine words that do just that, right? So the question becomes, right, why aren't those unlawful as fighting words? Well, we have RAV, we have Brandenburg that sort of modifies that admonition in Czaplinski. And speaking of Brandenburg, incitement, this often comes up in the context of protest and demonstration. Words that are used that threaten or seem to threaten the immediate breach of peace, right? But when we take a closer look at what's required to constitute incitement, we see that there are three parts to it. That the message or the statement must expressly advocate violence, advocate immediate violence, and relate to violence likely to occur. And so we'll take to the effing streets now or later. Is that incitement? Does that meet the standard of incitement? No justice, no peace. Is that incitement? Say something that might be uncomfortable for some, but from the river to the sea. By articulating that, does that invoke incitement under this definition? And so it's important. I think it's important that when we're thinking about these things in terms of speech, what's allowable, what's prescribable, you know, it all goes to application. But it's important to keep in mind what the principles are and what the rules say. True threats is another type of prescribable speech. That's speech that's, in other words, not protected by the First Amendment. And that case, that rule, true threats, emerged out of the Virginia versus Black case. It was a Virginia statute that criminalized the burning of a cross, burning of crosses, right? Recognizing that there are many messages that the burning of a cross can take. We know, or many of us, when we think of burning a cross and associated with the KKK, we think of it in its most nefarious, most odious, its most evil, and most threatening form, right, of a cross burning. But burning a cross could also mean different things or other things, more benign even, right? So the Supreme Court was careful in terms of describing, okay, what are true threats, right? And then even more, in that case, particular case, applying it to the particular facts there with regards to the cross and the cross burning and what could be criminalized and how could that be criminalized, right? And the presumptions that went along or should go along with any type of criminal prosecution under the law of Virginia. One other phrase or concept that bears treating because it applies here and it's often misconstrued is this notion of hate speech and the idea of whether or not hate speech can be prescribed, or is hate speech constitutional? RAV versus St. Paul at least settled that question. I would say not uncontroversially, but it's settled basically that hate speech is protected. And the gravamen here is this idea that what was going on with Minneapolis the St. Paul statute, St. Paul ordinance, is that it was basically unconstitutional because it was viewpoint based. And on its face, it discriminated on the basis of viewpoint. In other words, that, okay, you can say these things about race, but you can't say that about race. Or it was also seen as under-inclusive. Right? What about other categories of identity? Right? And why aren't they included there? And so those are applying sort of a constitutional interpretation principles to that statute. Right? And so that's why, and that's where we get into these very real conundrums in terms of what's allowed, what speech is allowed or prescribable, and what's not. And of course, there is, once again, the distinction between speech and conduct, and this notion that, conduct is conduct, and conduct can be criminalized, and conduct can be prescribed by private universities. Disorderly conduct, failure to disperse, resisting arrest, et cetera, et cetera, et cetera. Interference or obstruction of any building, et cetera. Trespass, disturbing school functions. Our policy sort of hangs its hat on the War versus Rock Against Racism principles, time, place, and manner restrictions. That was most clearly articulated in this case, with the first case that dealt with this. The idea, or the principle being that time, place, and manner restrictions are constitutional if they meet these particular requirements. So for example, in other words, a private university can say, okay, no loud noises between the hours of 10 p.m. and 7 a.m. Right? A university may lawfully say that, all things being equal, that protests or demonstrations can only happen on this part of the campus. Right? A university, private university, public or private, can lawfully say, right, all things being equal, that placards must be no larger than 10 by 10. Right? As an example of a manner restriction, right? So those are allowable so long as these qualifications are met, that the rule or restriction is content neutral, that doesn't make any reference to the content of the speech. For example, it doesn't say only pro-life speech is allowed between 8 a.m. and 4 p.m. Right? As long as it doesn't say something like that, that there's a significant government interest or a significant interest that is being pursued by the entity seeking to apply the principle, right? The idea that in the case of universities and institutions, right, there's this balance that is sought between, as we were talking about, between free expression and robust expression of ideas, yet trying to mitigate or reduce harm to members of the community. And public institutions, private institutions have legitimate interest in that. The question becomes, is it significant interest? Is it a compelling interest? Only needs to be a significant interest, right? And that is narrowly tailored. War versus Rock Against Racism did a little modification of the typical intermediate scrutiny test, to the extent that it didn't itself require, as it typically would in other cases, that the entity, that in this case New York City, implement or apply the least restrictive means of trying to fulfill their interests or their goals, right? And then finally, whatever the restriction, there has to be alternatives open to other means of communication. And I'm going to hand it off to John, but just to create this other, or bring this other idea to fore and problematize it, is this public versus private spaces, right? And so this doctrine, a foreign doctrine that talks about, okay, depending on how a particular space is designated, public, quasi-public, limited, or private, will dictate what a government is allowed to restrict, or what a government must allow to happen with regards to speech and expression, right? Public fora, like sidewalks, public parks. Now, historically, those have always been places where people can go and say and express themselves freely with certain restrictions, but never always on content neutral basis to the people who are for the people or agencies or entities that are regulating that space. It becomes problematic sometimes when you have private spaces integrated with public spaces, where you have a private space that the public is generally invited upon or walks through or walks in and out of. What then happens? What then is allowed by a private entity that exists in that particular space? And so with that, I'm going to hand it back to John, and he's going to talk a little bit about, I'll get to that later. He's going to talk a little bit more about forum and speech and expression.
Great. Thanks, Aaron. So I was going to say a little bit about particular issues that arise in the context of protest, a little bit about universities. Then I think Bryan's going to talk about due process, and then we can talk about policies here if we want. So generally, we understand one of the importance of free, or one of the things that's important about free expression and about the First Amendment is that it allows individuals to dissent and to object. It's part of how one causes change. One lets those in power know that what they're doing is not approved of or is disagreed with. And speech is obviously one way to make disapproval or dissent known, right? To exercise one's voice, to criticize, to condemn, to call for change. And typically, if that call for change is dramatic enough, it will be opposed. Right? Part of the whole point that expression has to be protected for purposes of protest is that those in power typically don't wish to give up power, don't wish to change, don't wish to do something different from what they're doing. And if it were up to them and they were able to just make their lives easier, they would prefer not to have to hear those that are saying that they are doing something wrong or that they should do something different. This isn't only true in the political context. We can say something very similar about, for example, the way the scientific process works and the importance of error and wrong ideas in that context. At a certain level, it's the same idea, right? That when we are comfortable with the way things are, we don't necessarily want to hear those that want to say something different. Often that means that protest has to occur in non-official channels, right? That if I wanted to call for dramatic change in the university, my guess is it would not be published in the Daily. Maybe the Observer would publish it. Maybe I would have to blog it or tweet it. Maybe I would have to find some other way of trying to communicate that information. But part of the importance in an institutional setting of allowing free expression is to ensure that those alternative channels are available. Obviously, when one engages in protest, when one engages in dissent, there are separate questions. They're not legal questions. They're not questions of the rules about what one's goals are and how you achieve them. Right? The message that is most pleasing to me may not be the most pleasing to my audience. The thing that motivates me might not be the thing that changes somebody else's mind. And those are important considerations. Successful protest movements, successful dissent movements have always had to struggle with the conflict between authenticity and being true to one's own cause and articulating a message in a way that will be heard by those with the power to make change. And those are important considerations, and I raise them because a lot of times objections to protest are styled in terms of objection to the way a message is being presented. And maybe as a matter of prudence, those who are engaged in protest might want to think about that. Does a particular slogan unnecessarily antagonize a particular group or another part of the community? So worthy considerations. But as a general matter within free expression regimes, whether it's the policy this university has adopted, whether it's the First Amendment and so on, the fact that others will object or be offended is never a reason to prevent the message from being heard. Right? That is explicit in the policy adopted by the Board of Trustees here. It's explicit in First Amendment case law. It's explicit in the Chicago Principles, explicit in ABA Standard 208, which applies to law schools that wish to remain accredited, and so on. There's a separate question about conduct. As Bryan has already mentioned, First Amendment protects speech and press, oral and written communication. It doesn't necessarily protect the sorts of conduct we might wish to engage in as part of that message. Right? I have the right to go downtown and expound upon a message. I don't have the right to block traffic. I don't have the right to prevent other people's ability to move around. I don't have the ability to block entrance or exit of a building. I don't have the right to take or appropriate someone else's property for my purposes. And in the context of protest, there is often a question, and that's tied into the question of how one wants to present one's message, of what sorts of conduct is one going to engage in as part of that protest. Right? Protests are often in public spaces where there are other legitimate rights to that space, other uses of that space that have to be reserved. Something that is related to that we often forget about is that one common form of protest, civil disobedience, necessarily involves the disobedience. The recognition that there are rules that are legitimate and that can and likely will be enforced, that one wishes to disobey. Right? We think of some of the most successful social justice movements historically have used civil disobedience of laws that were by their very nature unjust as a way of highlighting the unjustness of those laws. Right? So during the civil rights movement, the deliberate violation of laws mandating racial segregation as a way of highlighting the fundamental injustice of those laws. Civil disobedience often arises in the context where that is not the objection, right? Blocking of a highway by a group, or throwing a paint on a paint, or throwing soup on a painting. Right? That's not civil disobedience in the sense that there's something fundamentally unjust about hanging a painting in an art museum, right? There is some other injustice, and the disobedience is a way of attracting attention to the cause. But there's a disconnect there, right? Because there's nothing inherently unjust about laws protecting art. There's nothing fundamentally unjust about laws saying that people have a freedom to move and to use public highways and the like. But still, principles of civil disobedience involve recognition that when one is breaking the rules because they are seeking to advance their cause, they are acknowledging that the relevant sources of authority, the state, or in some cases a private institution, have the legitimate authority to enforce their rules and to punish accordingly. And that doesn't mean one shouldn't engage in civil disobedience. It just means that one needs to be knowing and thoughtful and deliberate about the means of protest that one is choosing, and how that's being done. And that's something that is important in terms of the speech and protest, because protest often involves activity beyond the mere expressive conduct itself. And traditionally, certainly if one looks at First Amendment law, right, blocking ingress and egress, blocking thoroughfares without permission, building structures, encampments, have not been considered First Amendment protected activity. Right? The First Amendment case law on encampments in particular goes back 40 years. National parks are not violating the First Amendment at all if they say you can't sleep out overnight. Maybe institutions should or shouldn't allow, right? There's nothing that says the parks or whomever can't allow that. It's a question of prudence, not a question of a commitment to free expression requiring allowing that sort of conduct. And when we talk about protests, we have to recognize that those distinctions often matter, right? There may be things we might want the government, a university to allow, because we think that's just better to be more permissive and to put people in less jeopardy of sanction. Okay, there's an argument there. But it's distinct from the argument about protecting expression as such. And that's something that you want to say a little bit about universities, and then you're going to do due process?
Yeah.
Okay, so let me say a little bit more about universities. Universities often aspire to something equivalent to the First Amendment level of protection. The Chicago principles, which have been adopted now by 100-some universities, and which our free expression policy that was adopted in 2019 was modeled on, aspires to the First Amendment as a floor of protection for expression. And that's for a variety of reasons. One of them, as I alluded to earlier, is that the core functions of a university are truth-seeking and education. And expression and openness of expression are essential to both of those. And for truth-seeking, it's essential because seeking truth requires error. It requires asserting and testing and challenging things that are false. Right? Think the scientific method. How does it proceed? By putting forward hypotheses and disproving them. Right? We advance knowledge by acknowledging and allowing things that are wrong to be put forward. And the history of every major field is littered with things that we now recognize as just being crazy pants, but that at one point in time were considered as true. In my class, today in con law, we were talking about the progressive era, talking about eugenics and all the kinds of things that were seen as the pinnacle of social science 100 years ago. And the people that challenged that were derided as crazy, as kooks, as radicals. Well, thank goodness we lived in a society where those sorts of pernicious beliefs could be challenged, where errors could be put forward that would eventually be recognized as truth. It also requires, certainly for education of adults, to be citizens in a diverse republic. There requires an openness to expression because of the great difference that we encounter throughout our society. And part of a university's function of educating people to be citizens in a diverse republic like ours requires an environment in which people confront and learn to interact with and agree with and disagree with and interact and exchange with those who are different from themselves, which further requires an environment in which official authority is as much as possible neutral as between competing groups. And that obviously can be difficult. But that is the basis upon which a lot of universities have aspired to embrace a First Amendment level of protection. Two other things that are worth noting. One, it is never the case that the government can force a private institution to suppress speech that would otherwise be First Amendment protected. We know that for a whole bunch of reasons. There's about 5 different ways we can legally get from A to B on that point. Right? The easiest ones are all federal laws, all state laws are inferior to the Constitution and so cannot themselves violate the Constitution, right? That's Con Law 101. But another reason way we can get to that same point is because private universities have their own First Amendment interests and their own First Amendment rights that the government is obligated to respect. So while there are obligations, legal obligations on the university to provide an inclusive environment and to prevent harassment and the like, none of those obligations can require a private university to engage or to suppress First Amendment protected speech. The one caveat to that is that if a university decides not to, on its own, adhere to First Amendment levels of protection, it can be obligated to be equal, right, to treat groups equally. And we have seen examples in the last year of universities that did not do that, that got themselves in legal trouble. Harvard being a very prominent example of that. A university that on its own chose not to abide by First Amendment standards. And then what may have been, to administrators, perfectly reasonable ad hoc judgments at the time, in retrospect were seen as giving different groups unequal treatment, and then that created legal jeopardy for the university under laws that require equal treatment. Last thing I'll say on this is that if we recognize that the why of universities is truth-seeking and education, then that helps reinforce the idea that things like time, place, and manner restrictions in the context of a university are those things that are necessary to allow the university to function in ways that allow it to achieve its mission, right? So having rules about what occurs during classes, being able to reserve rooms, things like that, certainly are necessary to the university's ability to function. People being able to get to and from class, necessary for the university to be able to function. But a lot of restrictions beyond that, it's certainly a much bigger question. I mean, the time, place, and manner formulation that I tend to like, because it goes back to a case called Granted from 1972, is that it allows for restrictions of speech that are, allows for the restriction of speech or expressive activity that is basically incompatible with the normal activity of a particular place at a particular time. And we can come up with a long list of all sorts of things universities would do under that rubric. And that anything beyond that, we have to recognize as actually university compromising one of its own core purposes for something else. That said, there are plenty of questions of prudence, right? Questions of, okay, we don't have to allow this, but should we allow it? At what point is a disruption too disruptive? How late at night does some loud event become something that's going to prevent people from studying or sleeping? At what congregation of people is going to sufficiently obstruct a walkway that the university is justified in moving people along? Right? There are questions of prudence, but the underlying principle remains. And there's also a question of, what degrees of sanctions does a university want to impose? And this will lead right into what Bryan's going to say about due process. The University of Chicago, which is generally viewed as being the initiator of the modern highly speech-protected university policy, is notorious for being incredibly strict when violations occur. So incredibly permissive about the range of speech and expressive conduct that's allowed. But you disrupt an event like this, you don't observe an order to disperse if you're physically obstructing walkways, or you try and occupy a building, you might not ever be on campus again. Right? So very broad leeway, very broad range of what's allowed, but very strict rules about knowing transgressions of those policies. And I'm aware of cases in the last several years of people being permanently expelled for things like disrupting an event like this one. But that is a question of prudence, right? That's a question of what sort of rules does the university wish to have for purposes of protecting expressive conduct, for protecting its functions, and the extent to which it thinks penalties are necessary for that. That sort of choice is distinct from the question of what is protected in the first place. But certainly in any context where there could be sanctions, questions of due process may arise, and I think Bryan was going to say a couple minutes on that.
Under any circumstance, under every circumstance, right, it's important to know what's allowable and what's not, and the consequences of certain conduct. As a fundamental matter, we talked about the rules and policies as a matter of strict writing and strictly looking at the language of certain rules and policies. That we first look to whether or not the policies are content neutral or are they content based. Is the entity electing to sanction only certain types of speech, certain topics, or is it allowing certain topics to the exclusions of others, right? That type of distinction compels different legal analysis, right? From strict scrutiny to rational basis when we're talking about constitutional principles, right? Often what comes into play are these questions of overbreadth, underbreadth, or an inclusiveness of particular rules or policies, and vagueness. And these become due process concerns primarily for a few reasons. One, the policy may not get sufficient notice as to what exactly constitutes a violation. If I don't know whether saying this thing in this context is a violation or not, then the likelihood is that I'm going to steer away from saying anything at all, which is a First Amendment transgression, suppressing speech, right? And then begins to look like a prior restraint. Right? So notice as to what conduct constitutes a violation or expression constitutes a violation is critical for legal analysis. Right? The second is discretion. When policies or rules or procedures say, okay, if you want to give a speech, if you want to protest that on this part of the campus, you have to apply, and you have to submit a permit, and a permit has to be granted. Okay, that may be well and good, but what if the permit is denied? What are the policies that exist for my ability to appeal that decision? And if the speech or expression that I want to engage in is such that it's of a temporal nature, the time is of an essence, that the moment might be gone tomorrow, are there provisions, are there processes in place to allow some type of direct appeal, an immediate appeal, right, to protect to the extent possible and practicable my ability to engage in free expression, right? The other aspect of the process and due process is this notion of discretion. Who's making the decisions, right? What's the risk that the person who's making the decision is going to deny my permit because they disagree with what I want to say or what I want to do, or the type of expression expressive behavior I want to engage in? And these are very real concerns, right? Another aspect of policies, and as Jonathan was intimating, right, there are many different forms of protests, right? There are visuals, there are walkouts, there are a whole host, there's chants, there's marching, there's sit-ins, exactly. All sorts of expressive behavior that conveys messages, either orally or through movement or through just vision, right? Just viewing, just being conveys a message, right? Do our policies and do our policies of approval allow for those types of expression, right? What if 100 people want to walk out of classrooms at the same time? What happens? What if 50 people are watching a protest that was legally sanctioned and they decide to establish they want to do a counter protest, right? What are the policies and practices, what are the policies that allow for that type of speech or demonstration or expressive behavior, right? And so these are very real questions, I think, that go to considerations or concerns around due process and fairness and discretion, right? And then finally, of course, above all, we're concerned about due process in that no policy should be unreasonable or arbitrary. And so once again, having clear policies in terms of the process for denial as well as the processes for punishment or sanction, right, are essential to, I think, any strong aspect, or should I say any strong policies that might be in place. I talked about these here, and there are also, I say finally, in terms of defining what's prescribed, right? What is intimidation? What is threatening behavior? How is it defined in the policies and policies of a private university? Does it track public sanctions, public criminal law, for example, criminal conduct? Is the intimidation that the university is referring to that they're prescribing, is it the same type of intimidation that the Ohio Revised Code, for example, prohibits? Right? Because intimidation in the Ohio Revised Code requires that the intimidation be personal, that it be directed to a person, not generalized. Right? And does our policy comport to that? If that is a rule, right? If that's something that we should be thinking of. Is a threat a true threat? We know, or at least the Supreme Court has attempted to define for us what a true threat is, but what is a threat? And can those be prescribed? These are some of the concerns about due process in terms of the language, content of the policies, what they allow and what they don't allow. And I'm going to just end there and just sort of, well, no, I'm going to end there, but I'm going to let John now talk about some more specifics of the policies, including Rule 208 and other aspects of some of our policies.
You're going to leave the controversial stuff to me.
Yeah, I'll chime in. Yeah, but I'm sure you won't have a problem with it.
No, that's fine. So let's say a little bit about how this applies here, and I will say I am expressing my own views. I'm not expressing the views of anybody else, but as some people here know, I was intimately involved in drafting the policy that was approved by the Faculty Senate and the Board of Trustees in 2019. So that policy, which as far as I'm aware is the only one that the Faculty Senate and Board of Trustees have ever approved, guarantees to all members of the CWRU community the fullest possible right to hold and express opinions, to speak and write, to listen, challenge, inquire, and learn, and says that except insofar as limitations on these rights are necessary to preserve the functioning of the university, CWRU fully respects and supports the freedom of all members of the CWR community to engage in expressive activities, as such activities are vital to the purposes of the university. Goes on to say things that are, I think, pretty standard for these sorts of policies about the fact that something is unwelcome, that something is offensive, is not the basis for excluding or suppressing views or speech, and that concerns about civility and mutual respect should not be used as a justification for closing off discussion of ideas. And then further points out that things that should be restricted other than those that are in categories of not protected speech are those that are directly incompatible with the functioning of the university. Under this policy, in this room, we have had people stand in the back of the room with signs objecting to a speaker. We have had folks protesting in front of the law school building. We've had folks hand out flyers. Other than the standing on the street, a lot of those things that have occurred in this room as well as elsewhere on campus are now prohibited on this campus, or sufficiently, or the language is sufficiently vague that one could not be ensured that that activity would not be prohibited on this campus. So, for example, under the current policy, we're an anti-abortion organization to sponsor an anti-abortion speaker in this room. It's not clear students could show up at that event wearing My Body, My Choice t-shirts, which would not in any way disrupt or inhibit the functioning of the university. In fact, I would argue would actually further the function of the university insofar as it would promote dialogue and remind people at that event that there is dissent and disagreement about an issue that matters quite deeply to quite a few people. But it would not prevent the speaker from being able to express their views. It would not prevent the people in the room from hearing the views of that speaker. But it would, in a non-disruptive way, ensure that other views, the people are aware of other views. I've maintained in writing and elsewhere that both the policy adopted in August and the revision are fundamentally incompatible with and violate the free expression policy that the Board of Trustees and the Faculty Senate approved in 2019. And my fundamental reason for saying that is because the policy adopted in 2019 says all members of this community, and that's an important distinction, because the university's free expression policies are about members of the university community. Whether it applies to people who are not faculty, staff, or students is a question of prudence and choice by the university, not a matter of that policy. The policy was expressly written to be about those who work, learn, study, teach here, not beyond that, because that's who the university is responsible to. That's who the stakeholders are. It guarantees the fullest possible right to hold and express opinions, et cetera. It speaks of speech and expression as being fundamental to the purposes of the university. And the problem with the rules that we're living under now is that expressive conduct is not treated equal to non-expressive conduct. It is restricted and punished in ways that equivalent non-expressive conduct are not. And how do we know this? Well, we can give a simple example. Let's say you and 10 other people at 10 o'clock at night wish to go across campus playing frisbee golf. There are conduct rules that would prevent you from making lots of noise, from obstructing other people's ability to use parts of campus, and so on. But if you are a student or a faculty member or staff member here, you are violating no university rule. If you put down your frisbees and pick up poster board that has a message, you are suddenly violating the university's protest policy. What triggers the policy as written is expressive conduct as such. The university has chosen to treat expression as a source of harm, as a threat, as something that must be controlled. Right? It is no longer in the behavior of restricting conduct that may or may not include expression, but that can get in the way of university functioning. Right? If I want to hold a parade to sing a song, if I want to do a hot-to-go procession across campus, and I obstruct people from getting to and from class, the university may prevent me from doing that or tell us to disperse because we are obstructing people from getting to and from class. If I do the same thing for a political cause, the university equally should be able to do that because students need to get to class. People need to get to their jobs. Right? That's a way of treating expressive and non-expressive conduct the same and saying, look, we have to function. And just because you want to say something, just because you have a message you think is important, that doesn't excuse you from the university's obligation to make sure the university can function. I'm sure I would disagree with administrators under that sort of policy about precisely where to draw those lines. I'm sure I would be far more permissive than a lot of folks. But the form of that sort of rule, right, one that does not target expression as such, that is focused on the university being able to operate, would be fully consistent with the policy adopted in 2019, fully consistent with the First Amendment, fully consistent with the sorts of free expression policies we see adopted at various universities, because it's focused on conduct. It's focused on the nature of the disruption. Not focused on speech being, and we could give tons of examples, right? If 25 of us tomorrow wanted to sunbathe, I don't think tomorrow's gonna be a good day for that, but if we wanted to do that on Freiberger Field and no one had reserved the field, we are violating no rule. If the field has not been reserved, a group of more than 20 people is free to go sit down there. If we want to sit down holding candles because we think there is injustice in the world and we want to hold a vigil for that purpose, and we should do it for more than 2 hours, hold the candles for more than 2 hours, we are now subject to sanction. If we want to lay out for somebody for 3 hours, we're not subject to any sanction. The threat to the university's operations is the same. If 30 people on the field are a threat to the university's operations, 30 people on the field are a threat to the university's operations. Whether we're laying on towels and putting on suntan lotion or holding candles makes no difference. Right? So, and we could do tons of examples of these. We could do these all day. But the policy as written targets expression. It sanctions expression. It treats expression as less than. And there are lots of institutions in which that might be a reasonable thing. Right? The owner of a shopping mall wants to do that, fine. But we're a university where expression and ideas are core to what we do. Again, my own view is that not only does that violate the 2019 policy, it is particularly problematic given our aspirations as a place that promotes truth-seeking and education. There are other little things we could talk about in terms of the details and so on. But at its core, that's the thing that I think needs greater examination and focus. One other thing that, and Bryan put up, American Bar Association this past year, as a reaction to events that occurred in a bunch of law schools, both threats of sanctioning of faculty members or other members of the community for expressing views that were deemed impolitic or offensive by other members of the community, or events that were disrupted, where speakers were prevented from speaking, felt it was necessary to adopt a standard, an accreditation standard. So a standard that is applied to law schools when they're in the accreditation process that relates to academic freedom and freedom of expression. When that policy was released last spring, a whole bunch of us thought it was very clear that this policy requires law schools, public and private, as a standard of accreditation to adhere to First Amendment principles. I know not everyone had that interpretation. This past week, the ABA issued a guidance memo for how it is understanding and applying Standard 208, and there is now no longer any doubt because it is explicit. In the portion of that memo, it goes through things we've already talked about why free expression is important and academic freedom are important in academic institutions, and in particular in the context of the study of law, where, given our adversarial system, the ability to confront and deal with and articulate opposing views is particularly important to being an effective lawyer, goes through what it understands these various principles are, and in the guidance on the section that discusses the context under which law schools may restrict speech, including things like time, place, and manner restrictions, makes very clear that this subsection will be interpreted consistent with the First Amendment of the US Constitution. It goes on to note that scenarios could arise where there's no case law. And in that context, there's questions of good faith, and are you making a good faith effort of trying to comply with with the rules there are. But then goes on to say that once doctrine is clarified, schools are expected to comply with the applicable constitutional law. So if I'm correct that the policy the university has adopted is not only not consistent with its own free expression policy, but with First Amendment standards, that could be an issue since the law school's up for reaccreditation next year. It goes on to point out that within the First Amendment, it's possible to ensure that a university functions properly. All of our state peer institutions seem fully capable of doing that. In fact, in recent years, it's been, with the exception of UCLA, which violated all sorts of laws, most of the problems have been at private institutions. I think not coincidentally private institutions that chose not to tie themselves to the mast of First Amendment protections, right? Most of the schools that have had legal jeopardy in the last year were private institutions that chose not to tie themselves to First Amendment standards. But I think if we look at the experience of state institutions, having to comply with the First Amendment doesn't mean anything goes. It doesn't mean a school can't provide a welcoming and safe educational environment for its students, staff, and faculty. It means there are certain guidelines that prevent unnecessary restrictions. I would also argue it provides a set of answers to a lot of tricky questions that make it easier for an institution like a private university to stay out of trouble. Because instead of having to make up every answer from scratch or try and reason from first principles, there is a very robust and thick body of case law that considers and explicates how these principles may apply in different contexts so that there's something to rely upon. And in fact, I and others, Kim Urako and Max Schatzenbach at Northwestern, for example, have explained why universities that are concerned about things like Title VI compliance are in less jeopardy if they tie themselves to the First Amendment, because that's a way of preventing them from engaging in discretionary choices that seem reasonable at the time, but with the benefit of hindsight appear to be biased or unfair. So it's not a claim that the university can't have rules, it's a question of what sorts of rules can the university have. I will stop there because I've probably gone on too long. And I'm going to turn it back over to you, and if people have questions and comments and stuff, we'll discuss.
I just wanted to add, and perhaps I guess in the process, emphasize some of my abiding concerns about our current policy, and I'll just start with 208 as well, and saying that I think that 208 is pretty clear in terms of what our policies around free expression should look like, and what law school is bound to abide by. We're obligated, of course, to abide by the university policy, but when that university policy conflicts with our accreditation rules and regulations, that's a very real problem, and it puts the school at a very real risk of being in danger of violating the ABA rules. And so when we talk about the issues of tethering our rules and policies to case law, to Title VII, to Title VI, particularly with regards to anti-discrimination, anti-harassment policies and provisions that have been fully fleshed out by case law, not fully fleshed out, but sufficiently fleshed out by case law. There's some there that we can hang our hats on, and that goes to another one of my concerns about the invocation of language and terms that have no clear definition, or definition that's grounded or tethered in existing law, or law that the school can look to and say, okay, this is what it means to engage in a true threat. This is what it means to intimidate. This is what it means to incite. not seeing that, not having that, I think creates real problems. I too am fully in agreement that we need to maintain and have a place that's welcoming and that's open to everyone, all views, all viewpoints, all peoples, and that everyone has a right to exist here and to be here and to share those ideas, and take benefit from those ideas, and people should not be excluded because they are being harmed physically, even psychologically, right? But once again, we balance those needs and those goals with very real and very important aspects of what it means to be at a university, what it means to be at an institution, for the exchange of those ideas, for those values that we hold as part of our mission to educate, right? And where and how we best seek truth, how we so I won't go on any longer. My thoughts, we want to open it up to questions or thoughts that any of you might have, so we'll just call on anyone from here. Thank you. Hey.
Thank you both for very informative event and presentations. I have a question about what happens in the case that the standards that the law school is supposed to abide by are in conflict with the wider universities. Like how do both how does the law school and then the greater university go about like figuring that issue out so that there is no accreditation violation?
Well, I mean, there's no conflict between 208 and the policy that was adopted in 2019.
Okay.
The conflict is between 208 and the policies, right? There was one adopted August 5th and then one, I guess, August 28th or something. The policy that was adopted this semester. There may be questions about actions the university may or may not have taken last spring, although we have to be careful with that because the university can't fully, insofar as the university took action in certain contexts, the university, because of things like FERPA, can't explain the full basis for its actions, and at least from some of what I've seen, some accounts of disciplinary action the university may or may not have taken have not been complete. So, but there's possibility, there's possibility of concerns there, right? Typically in an accreditation review, if the ABA believes a law school is not meeting those standards, it can require the entity to cure, and if things aren't cured in a sufficient period of time, that can ultimately threaten the school's continuing accreditation. The guidance memo that was released last week includes a discussion of how it will be enforced. It does remind folks that it is not relying upon the way the university or school characterizes its own policy, and that it expects to obtain submissions from other members of the community about how the policy exists and has been enforced. There's also a separate issue, possibly, in the sense that Ohio, like most states, treats things like student codes of conduct and other statements like the free expression policy as contractually binding on the university. And so there are also potential legal issues there if a case could be made that someone was disciplined in a way inconsistent with the policy. Again, I don't feel comfortable saying whether or not that's happened or not. I feel comfortable saying that there is language in the new policy that, were to be enforced, would raise those concerns. But it could put the school in a difficult situation. Last thing I'll say, could the university have a different rule for the law school than for the rest of campus? I suppose. I'm not entirely sure how that would work. I will confess my own personal view. I'm not sure why the university, if it meant what it said in 2019, which I'm pretty sure it did. I mean, faculty senate was overwhelming, board trustees were overwhelming, why it would want to. Because I don't think that's necessary, right? One, it's not necessary to prevent disruption of campus activities. It's not necessary to prevent disruption of normal functioning. It's not necessary to comply with state or federal law. But if the university feels that way, one possibility might be trying to figure out how to have a different set of rules for law students or for what occurs in the law school, I guess. There could, for example, be different rules that apply in this building as apply in another building. But I don't know of any university that's sought to try and do something like that yet, and so it's a good question.
No, that certainly would be very interesting. My life as a law professor, I've been on at least, I think, maybe 10. And so I've been tasked with not only doing them myself or being part of a team that write the accreditation application or reaccreditation, but to analyze. And so we just got the way it goes. You get forms from the ABA laying out various provisions from 1 to 8 or 9, and question 208, it will ask you, okay, what does your school do to ensure the fullest the policy of freedom of expression as expressed in our Rule 208? We are obligated to say this is what the school does. And the follow-up question in the questionnaire is, does this comport with the university policy? What is the university policy? If it's not the same, explain the difference, right? There, you have to respond to that, and that's the flag, and then and then all things being equal, that might be one thing that the review, the bureau, that the ABA say, okay, this may not be, they might not be in compliance. They send a letter of inquiry asking us to, explain why there's a difference or distinction, and there's attempts to resolve it. We attempt to resolve it. I think it may be on a positive. There may be ways or room. Someone, maybe Rob or maybe Eric, have done these before. For a university to exempt, for example, a law school from its more strict policy, but I can't say I personally have seen that, but it's a curious thing, and certainly something that's maybe I would think possible, but in this case, I stand with Jonathan, who's looked at this much longer and harder than I have. Why would, if we had a perfectly or say good policy in 2019, why we want to create an exemption? Or how could we create an exemption for ourselves that makes any sense?
Wouldn't creating the exemption almost kind of like make the school look worse in the sense that then it is like you're openly admitting at that point that law students have the freedom of expression, and then there's kind of this like exempt group? Like, wouldn't that kind of put case under more fire, like as a whole, if like the law school was under like different expression rules?
Maybe.
No?
I mean, I would argue that the university is actually kind of fairly lucky that there hasn't been more public attention to the rules that have been issued this semester. I know, for example, Fire is aware of those rules, but my understanding is they have sent private letters to the university administration rather than making a public issue of it yet. I'm not sure how long, that will be their approach. I mean, I said, unless one believes that, Penn State, Purdue, Ohio State, whatever, are somehow incapable of fulfilling their educational missions and providing welcoming environments, right? Why would one want members of our community to have lesser expression rights than members of those communities? And I can only think of two arguments for that, neither of which I would want to publicly defend, right? One is that somehow members of our community are not sufficiently deserving or capable of exercising those rights to expression, which I would never say about the members of this community. That's certainly not been my experience. The other argument would be that perhaps our administrators are just not capable of respecting those rights and fulfilling the university's other missions. And again, in my 20-some years of experience at this university, I don't feel that way about our administrators either. But unless one of those two things are true, it seems to me there would be no reason we as a university would want to publicly say the degree of expression that all of our esteemed state university peers are capable and indeed legally obligated to observe, we don't want to observe. And again, that doesn't mean anything goes. It doesn't mean letting what happened at Columbia happen at Columbia. Again, private institution that did not apply First Amendment standards consistently. It does not mean not enforcing conduct rules. Right? University of Chicago enforces its conduct rules, which the First Amendment is a floor, not a ceiling in terms of their approach, enforces conduct rules far more strictly than we do. Right? There would be far more than one student not allowed on campus this semester if we applied the University of Chicago approach. If the allegations that are true in terms of defacement of property, blocking walkways, encampment once it was prohibited, and so on, were substantiated. Right? We know that. So there's no conflict between protecting that broader degree of expression and protecting the university's function, in the sense that we know universities are capable of doing it. We see it all the time. So I would think the embarrassing thing is our saying, well, even though it's doable and other places do it, we don't want to do it. And that to me seems to be from a PR standpoint a bad admission.
Taylor president 2019? Sorry.
No, Barbara Snyder.
No.
Barbara Snyder was president. I give a little bit of history of this. So Barbara Snyder, who at one point was a member of the law faculty here and also had been a Jeff Stone student at the University of Chicago, became convinced that the university needed to do more to encourage civil discourse across difference and to do more programming focused on that, and that part and parcel was ensuring that everyone on campus understood that civility was not a rationale for curtailing the expression of ideas. So after some presentations that I and others made to the Board of Trustees, the Faculty Senate was asked to put together a committee to draft a policy to say what many of us believed was implicit in many other existing university documents. So if you look at the free expression policy adopted in 2019, there are footnotes to other university documents that relate to academic freedom and the nature of inquiry and so on, in which open expression is implicit but not explicit. And so the idea was to make it explicit. And so the committee, again, with her support, drafted a policy that was presented to the Faculty Senate Executive Committee and Faculty Senate, and then ultimately to the Board of Trustees, and was part of. But it was Barbara Snyder was president at the time.
Aisha.
I don't know if a student has a question, defer, but if not, so I would love if you would speak a little bit. I have two questions. I'm just going to put them out here so that you have them. The first about the comparison to how an entity treats speech from one group versus another group. It seems like a fraught frame of analysis, specifically because those often who are trying hard to be heard and to have their rights protected are not in the same position as those who are, subjecting them to oppression, if you will, right? Those who are oppressing have very little to gripe about. And so I'm wondering if you could just explain a little bit more from the viewpoint analysis of what's allowed and what's not allowed, how much weight is given to that factor, right? How one group is treated versus the other, because one group has not a lot to complain about. The other question that I have is on the private versus public distinction. Seems reminiscent to me of Southern rights. And Southern rights, Southern rights, right? Where Southern states wanted to promote their desire, right, and wanted to have the right to provide less protections than what the federal government, even if there were aspirational protections from the federal government, than what the federal government was seeking to do. And I wonder if you could speak more about the private versus public dichotomy. I appreciate your comments, John, generally about the difference between Cleveland State and Case Western, right, and the rights that our students have. But I really am curious, and there was a slide there that had some pieces and parts around public-private and the like, but I really would love to hear you both or one of you expound more on this notion of what it means for us to be this private university in the middle of a very public space.
I'll start with your last question first, with the public-private distinction, if I may, and try to do it justice, respond to justice. Traditional public forum, that's perhaps the most straightforward and easy to understand or conceptualize. A sidewalk, a public park, those are places that the statement is for time immemorial, have been seen as quintessential spaces where people, general public, can go and speak and express themselves, subject to reasonable time, place, and manner restrictions. For example, a city or a public entity can require you to have a permit, or it can say you can only do this in this part of the park, et cetera, et cetera. You can walk and march down a sidewalk, but to the extent that it begins to obstruct traffic, et cetera, et cetera. But that is the broadest, right? I'm going to go then to proof. The other ones, designated public forum, limited public forums, those spaces where a governmental body elects to have a particular space for speech, generally, or a particular space for a specific type of speech. And so we saw some of that animated in these cases that I was talking about. Perry, Christian Legal Society. Perry was a case where it was a public school and mailboxes, and a group. It was a unionizing issue or a union issue where a competing union wanted to put flyers in the mailboxes of the teachers at the school, and the court said, well, that was okay. They could exclude that speech. That was kind of unique there with regards to that. But in doing so, Perry laid forth these various categories of public-private. Purely private property, yes. Where it is a wholly owned private property, generally speaking, one can restrict speech and expression. School would be an example.
Would the school be an example? That's, I guess, where I wanted to have some thoughts, to hear you all's thoughts around, right? Like, I understand the assertion that we are a private organization, as the president has told me, right? And I can't help but be mindful of the fact that we have so many public spaces directly abutting where we are, adjacent to where we are, and that there are so many public dollars that are connected to this institution, right? And that I often host events here that welcome members of the public, right, time and time again. And so I guess I'm just really trying to understand if, and maybe none of the case law that you all have analyzed up until this point has hit on this question, right? But isn't there an argument to be made that this is not a fully private organization?
Yeah, okay, yeah, so let me try to get to that, right? So, as a general proposition, we are a private institution. There are certainly places and spaces on this campus that are purely private. That doesn't mean that we are not subjected or subject to First Amendment principles or laws, because once we decide to articulate in our mission these statements about free expression, et cetera, et cetera, et cetera, that sends us down a particular path, a particular obligation. The complication you raise is that, okay, you have this private university, but you have public spaces on it. You have spaces that you have a hospital. You have other public property or public spaces that people move through this property on. And so what is exactly the space that can be legally governed by Case Western Reserve University, right? What spaces can they not say you have no right to be on because, well, this is not your space, Case Western Reserve University. And so that's why I think that complicates things. There was a case called U.S. versus Coquinda that deals with post offices, and there was just one sidewalk that went from the parking lot to the post office. There was a no solicitation rule or regulation that the U.S. Post Office had, and there was a group set up a table, wanted to or was attempting to sell some materials, but also talk about the topic they wanted to talk about. The people who were there were arrested and fined. They challenged the rule as violating the First Amendment, and that case also became sort of one of those seminal cases that sought to explain the distinction between public and private spaces when you have a government a public post office that is ostensibly a public place, and then you have a sidewalk that is the only sidewalk but is ostensibly a public place. Can the government, within First Amendment stricture, regulate that? The court answered yes in that case. But it is a real complication. Another case where you had a military, and the name of the case is escaping right now, a public sidewalk that went through a military base. And a person wished to protest on that sidewalk that went through the military base. The court there again said that no, the military is a unique place. It has a certain function, serves a certain function. Therefore, we have the right to regulate that ostensibly public place. So I do believe it does get complicated, and I don't know if that helps our answer or not at all.
Let me jump in on that. So I would give a more categorical answer that you won't like. The university is a private institution. It has its own First Amendment rights, right? Which is why, for example, if the state of Ohio wanted tomorrow to rewrite and dictate the curriculum at Ohio State, it probably could, because the state can hire people to deliver the state's message, government speech, and praise Congress. It can't do that to us because the university has its own First Amendment rights as a private entity. As a private entity, it also then can control what speech occurs within. So a university that did not care about having a law school accredited under Standard 208, and that is not in California, because California has chosen to enact a law called the Leonard Law, which subjects private universities to First Amendment strictures like public universities, does not need to abide by the First Amendment internally. The fact that it receives federal money does not matter because there is no federal law saying that universities that receive federal money must adopt the following speech policies, and there would be questions of whether or not that would even be constitutional. The university, by holding itself out as a university, where academic freedom matters, where inquiry matters, and the like, is binding itself in that direction. But it's done so by making those choices. But there are plenty of private institutions, and most of them are religious institutions, right, that have chosen to publicly embrace principles, creeds, missions that do not entail full free expression, and they're allowed to do it. And Standard 208 has an exemption for religious institutions. The Leonard Law has an exemption for religious institutions. But the university, as an institution, didn't want to have a law school that abided by 208 and didn't actually care about the core missions of inquiry and education, could choose to throw these things overboard. Where it possibly gets complicated, and this may actually then implicate questions of things like property law, is how do we understand the nature of the university's ownership of certain spaces? And to what extent could one argue that there are de facto public rights of way across certain parts of campus in terms of open spaces, or that the university has held certain spaces out and open as public spaces, and would that constrain the university's ability to change its mind? And those are interesting questions. I believe the only case in Ohio law on this is an intermediate court from a long time ago that I would be reluctant putting too much weight on, but that does suggest that there's a prune yard-like rule where certain sorts of private institutions that hold themselves open to the public as public thoroughfares give up some of their ability to police speech and expression within those spaces, particularly if they are not themselves engaged in speech on that topic. But that really hasn't been litigated. So my own view is that there are reasons, contractual reasons, why this university should abide by these principles. There are practical reasons in terms of standard 208. There are very powerful, to me, normative reasons why the university should. And I believe the university having a relationship with its community is an additional reason why the university should want to respect these principles. But as a pure legal matter, the university didn't care about an accredited law school and were willing to openly and expressly disavow the promises it has made to members of this community over the years about protecting their fullest right to speech and expression. As a private institution, it could do so. It would be a much smaller and less valuable place for doing so. But legally, it could.
You have a second part.
About the power? Yeah,
Go ahead.
super quick on that, this is oversimplifying. Those in a position to restrict speech, by definition, are those in positions of power. So rules about open expression and viewpoint neutrality in their operation systematically tend to benefit those with less power because they're the ones that otherwise would need permission. Now, can we come up with counterexamples? Sure, but in any given space, right, so the groups here on campus.
Yeah, I'm clear on that. I'm asking a different question.
Okay.
I understand how power dynamics work. What I'm asking is where that factors in you all's analysis about viewpoint discrimination, right? So how much weight is given to this comparison between how often, right, an entity decides to prescribe speech or expression by one group when there isn't any expression or speech by another group because that group holds power.
Okay, I see what you're saying. It makes it hard because, like any legal inquiry in alleging, or any legal inquiry looking into potentially discriminatory conduct, it's hard to make out a case for discriminatory conduct absent a counterfactual that we can observe. And this is a problem across a wide range. I mean, there's a wide swath of areas of law where that's just hard. That doesn't mean it's impossible, but it is difficult. In my mind, to my mind, that's one of the reasons why institutions that are committed to free expression want to be particularly reluctant to use things like offensiveness or intimidation in the abstract and whatever as a basis for restricting speech, because it's too easy to think that what one is doing is embracing a neutral principle when what is in fact doing is suppressing the message they don't like. Right? So one of the reasons we want rules that constrain decision makers is because it protects against the natural human tendency to reach the conclusion that you want to reach. And that's particularly likely to happen where there's the sort of power differential you speak of. That more helpful?
Yes.
What he said, yeah,
Yep.
exactly. But Eric, and then
Just to put a finer point on something, and I am an academic, so I'll ask a question I know the answer to. It's two questions. First off, in regard to Standard 208, there's no distinction between a public and private school, correct?
Correct. The only distinction is for religious institutions that have an express creed, and that is arguably required by the free exercise clause. So if you apply the First Amendment wholesale, you automatically have that exemption built in.
In addition to that, I mean, when an ABA site visit occurs, and this is for Bryan, there's a specific question about whether or not the university has policies that contradict ABA standards, right? So, as a result, when they show up in 2025, we probably ought to have our act together, right?
yes, definitely. Well, we're going to get SEQ months before they show up, or at least several weeks before they show up. So we got to have our stuff together before then, right? But it is an explicit question. To what extent? Show us the university policy. If there is a distinction, what is it and why? I had a particular my last site visit. A very specific, controversial distinction between what the law school was allowing with regards to one thing versus what the university was allowing, and so that required some digging and some writing. Now we just call balls and strikes. We just advance the facts. We don't make the determination of the site visitors. We just say, okay, this is what we found. Yes.
Yeah, I'm just thinking about this because it's a really relevant example to Ohio, and I think it might help kind of parse out the distinction between public and private universities. I'm thinking about when Senate Bill 83 was passing through Ohio. I'm sure some individuals in the room are familiar with it, but it was essentially, more commonly known as like the anti-critical race theory bill that was going through Ohio. And there was a lot of discourse at the university, because we're a private institution, about how if something like this were to pass would affect OSU versus here. And that bill's a little weird because it claims that it's expanding expression when in reality it's kind of emboldening hate speech and things, or at least, very, I would say, fueled speech. So I'm just kind of wondering, maybe using that as like a grounding example, where is that line drawn? Using an example for this quote unquote bill that's about speech as it relates to like education and academics. We've had discourse at this university before. How would, for example, legislation like that be different at a public university versus us as a private university as it relates to being content neutral, being applied differently because of that public-private distinction, and if there was any insight that could kind of provide to the current context of what we're facing at this university.
So the bill that was just passed ends up treating state or public and private institutions separately, largely to try and sidestep a lot of those issues. This is an oversimplified answer, but a private university, you have the speech rights of the members of the community that are protected as against the government by the First Amendment, and you have the speech rights of the institution itself, right? So that the academic freedom exercised by the faculty as a collective entity has First Amendment protection as against the state. The school's curricular choices have First Amendment protection as against the state. At a public university, it's not clear that is true. I say not clear that it's true because there's relatively little case law, though we're about to get a bunch, mostly from other states. But the way to understand that is that, you still have the speech rights of the members of those communities. But the institution itself, because it is a state actor, is a government speaker, not a private speaker. And so there's at least a very serious argument that, for example, the curricular choices of Ohio State are the choices of the government to speak, and the government can choose what messages it wants to speak, right? The government can say, is it possible that courts will think that there is a meaningful constitutional distinction between universities and K-12 education along these lines? Maybe, but I doubt it. And largely because it's not clear what the boundaries would be. But so, for example, a school could say in 5th grade, biology class will teach the following things. And to have a job paid for by the government in this class, you must teach the following things in the following way. We might think that's terrible or awful. We may think we may have a dispute about at what grade that sort of thing is appropriate, but the government could do that. Not clear why the government could not do that at the university. So when you went, so insofar as you have these bills in various states that are aimed at altering what state institutions teach, it's not clear you get very far with First Amendment arguments in terms of what the entity itself does, in terms of its curriculum and so on, and what it allows. The sorts of equal protection arguments might want to make if one thinks that those standards are discriminatory under current law are hard. Not that you can't make them, right? Not that they're not colorable arguments, but the state legislature would have to have some really bad lawyers to draft a bill, and then the state government would have to have really bad lawyers doing the implementing regulations to leave themselves open to an equal protection challenge. Not that it couldn't happen, you see it, but it'd be hard. And that's, I think, the best way to think about it. Now, note, California does have a law, a bunch of laws that apply standards to public and private universities across the board that have not been challenged. The Leonard Law applies First Amendment to private universities. They just enacted a law today that bars both public and private universities, or alters admissions policies for both public and private universities. Interesting questions about could that be litigated, but Ohio hasn't done something like that.
Would it be relatively fair, this is obviously going to be pretty reductionist, but to say that public universities, they're acting much more as spokespeople of the government by nature of being public, but private universities may not be subject to as many of those restrictions. However, the kind of caveat with that is that private universities then get a bigger role in governing what speech is protected at their own university.
Yes, yes, right. So government employees have First Amendment rights as citizens, but not as government employees. And the case law on that line in the last decade or so has been less speech protective. So now there are also due process issues, right, which are going to matter a lot of universities, right? So if Ohio State, just as an example, has in the faculty handbook and stuff really robust protections about academic freedom and so on, that's traditionally been understood to entail a certain amount of freedom in course content and whatever else, that is contractually bound by that, and it would be difficult to just unwind it like that by legislative fiat. That'd be a transaction cost of making the change in some respects if a state really wanted to do that. And we are seeing some states that are being pretty aggressive in that direction.
You teacher,
Okay.
maybe
I guess my question is this. In a situation where a university like Case Western holds a career fair and students go to this fair and distribute information about some of the tabling employers who are at this fair, an administrator approaches these students and says, you can't do that in here, this information is upsetting, or they say it's disruptive to the event, would it be content neutral then to place a restriction that these students distribute this information outside of the premises?
Well, it'd be consistent. It would arguably be consistent with the university's 2019 policy and with the First Amendment to require the distribution to be outside of that particular event, because the university could argue this space is reserved for this particular purpose at this particular time, and just like you couldn't come into my class and distribute flyers during my class because you think I'm teaching people terrible stuff, but at least I would argue consistent with the university's 2019 policy, you would be allowed to distribute that information elsewhere on campus. The university could do that. Now, are there questions about notice and the like before the university could punish in that scenario? I think so. But the university informing somebody that we think you're disrupting and giving you the opportunity to stop disrupting will often satisfy that requirement. Now, there have been some events recently involving career fairs where what was done was more than quietly handing out flyers to people that were willing to take them, and there is nothing inconsistent with the First Amendment or with a policy like what the university adopted in 2019 with sanctioning students that engage in such conduct. Again, whether or not the university should have that policy where it would sanction those questions is a question of prudence, a question of kind of the way the university wants to run things, but I don't think implicates the free expression principles in the policy or the First Amendment. Does that make sense?
Yes, and then just to follow up, if they're distributing only a list of organizations, is it kind of the same deal?
I mean, look, if the university wants to say this space is used for this purpose at this point in time, and only for that purpose, the university can do so.
Okay.
Right?
Yeah.
I mean, it's like the university saying, KSL Oval is going to be used for the graduation procession on this day, and no one's going to protest on KSL Oval that day. The university can do that. Now, would I be that restrictive? I don't know, but it's really no different than, like, I don't know if anyone's ever been in Washington, D.C. for inauguration, right? I mean, if you want to protest the president being inaugurated, you're like 5 blocks away inside a fence. Is that the policy that I would adopt in my world? No. Have those sorts of restrictions been upheld as being consistent with the First Amendment because on that day the relevant public spaces are being used for a particular purpose? Yes. And so just we want to distinguish between kind of what are the matters of free expression principle and what are questions of prudence about the sort of community we want to build. And the things like, are we going to have an alumni event or a job fair or whatever else where we are protecting that from outside interference, that's really the question of prudence. But I should note, the principle is very similar to If a group wants to reserve this room for a teaching to present a particular message, right? Their ability to limit what occurs in that space during that time is broader than we would think of as applies to generally on campus, because as a university we allow people to group together to pursue their points of view or what they want and to reserve spaces for that purpose, and we provide that right to all community members, and we require that to be respected. And again, we might, in my world, if someone wanted to sit, if it was a public meeting and someone wants to sit in the back of the room holding a sign, not obstructing anybody else's view, and not shouting anybody down, I'd allow that. Is the university required to allow that for every event? Not clear that its stated policies require it going that, taking that position in all contexts. And certainly for something like a job fair, I don't think the university's policy obligates it to do that. Because that event is not about truth-seeking and exchange of ideas, right? That's about helping students find jobs after school, and that particular purpose doesn't have the same connection to expression and exchange of ideas as the university's kind of ordinary everyday functioning. Just like commencement doesn't, just like an alumni event doesn't, just like,
And those most clearly fit, the stated policies in terms of significantly disrupting sanctioned events or activities, right? Those would arguably come on those categories, and so would more rightfully be permitted to restrict the type of speech and that expression that goes on during those events.
And super quick on that point, because I think it's relevant to the way the university's policy has evolved. We generally, First Amendment law generally recognizes that time, place, and manner restrictions, right? It's not reasonable time, reasonable place, reasonable manner. It's the restrictions are reasonable in light of the purpose that the institution is trying to fulfill. So conceptually, the policy the university does not map onto the relevant First Amendment doctrine, but allowing extra protective rules for special times and special events is viewed very differently than we're going to have across-the-board rules that apply every day about the when, where, and how you can do stuff. And there are good reasons for that, right? Because an institution is going to have special events, it's going to have special times that require a degree of control or curation that not every day requires. And so, a policy that's consistent with First Amendment principles might say, okay, the job fair or commencement or whatever, it's going to be clamped down, but day in, day out, it's going to be a lot more free flowing. And that part of the idea there is that is fulfilling the idea that there's ample alternative ways to express your message if it's 2 hours on Tuesday in one building that you can't hand out the flyer, but you otherwise are allowed to. And that's the idea.
This gentleman, I'm sorry, should I have a question and then you next?
So, Professor Adler, you've talked about the university's freedom of expression policy. So, I just have about suppressing speech that somebody found offensive.
Mm-hmm.
So, does the university have a right to outright ban a certain phrase and have multiple follow-up meetings with students for merely being in the presence of the phrase being used, knowing that this phrase is commonly associated with certain speech and that this action will deter members of a certain group from freely or feeling safe with expressing their speech?
So let me say two things. One, hypothetically, and two, I'm not your lawyer. Hypothetically, let's say there were a phrase that many people find offensive that is contested, say from the river to the sea. And let's assume the worst about the meaning of the phrase, right? Let's just posit that, right? Because it is like a lot of phrases and slogans in our society. Different groups, because of what they bring to the discussion, view a certain slogan or a certain message through their own lens and may view it very differently than another group. And so it's useful just for thinking through this to assume the worst, because I think it's clarifying. So let's assume that that phrase is understood to mean that the state of Israel should cease to exist, and perhaps even that there should be something tantamount to the removal of all Jews from that space. Again, I'm not saying anyone necessarily embraces that when they articulate that message, but let's assume that. If one is applying First Amendment standards, the generic invocation of that phrase comes nowhere close to unprotected speech. It is no different than the silliness that the Klansmen were saying in Brandenburg out in the middle of that field. Why? Because there is no directedness, there is no imminence to any sort of threat. And another way of thinking about it is this. As a member of the faculty, if I believed that a particular group of people was entitled to a particular plot of land on the globe, and I wanted to write an academic article making that case, clearly that would be protected. And some may find it offensive, but there are all sorts of questions of geopolitics that are very offensive, right? People defend the dropping of the atomic bombs, particularly the second one in World War II. Do a lot of people find that offensive? Of course. Do people even find that potentially genocidal? Well, maybe. But is that a position that a member of the faculty could explicate in a paper as part of academic freedom, without question? Well, could they then title the paper with a slogan that kind of encapsulates that view in a catchy way that different people, and maybe title the paper from their, well, of course they could. Well, could they then tell somebody about it on campus? Could they tweet about it? I mean, nothing there creates an imminent threat, as understood in it. Nothing in there, if it's not directed at a person, is involved in harassment. Nothing there entails a threat of violence here and now, which is the standard that's always applied. It might be an endorsement of violence somewhere else, right? Again, for the sake of argument, let's assume that it is. But to me, it's no different than if someone wanted to say, bulldoze Gaza, right? Are there people that believe that? Sure. Is that a position that many would find offensive? Of course. Is it a view about a geopolitical conflict that one in Cleveland could espouse without creating a threat or anything that we would recognize as harassment? Again, if just generically stated? Yes. And so if we aren't going to be viewpoint discriminatory, if we are going to apply First Amendment sorts of standards, what we're looking for is things that are targeted. And they can be targeted in a lot of different ways, right? So the question becomes more difficult if we start talking about tagging people on social media, if we talk about distributing information or holding protests and things in particular places that are not seen as places of general discussion. Then there are harder judgment calls about what is harassment and even what is kind of within the community maintaining certain neutral norms of conduct towards other members of the community. But in my own view, I would say there is no jurisdiction that I'm aware of that would find that even a remotely close call if they are applying First Amendment standards. And just as an example to illustrate the point, just in the last week or so, Meta, which some of you may know, has an oversight board that handles these sorts of disputes internally. Meta does not follow the First Amendment. Meta, for example, does not allow what it considers hate speech. So Meta proscribes speech that is protected under the First Amendment. Meta just released a report saying that absent other contextual elements, the phrase by itself does not violate Meta's terms of service. And if I recall correctly, the report examined 3 separate examples of it being used. And I think it was correct. If you look at the people who were on Meta's oversight board, I mean, there are some real heavy hitters in terms of their knowledge of free expression policy and so on. I should note, that doesn't mean that anytime everyone used that or some other phrase, it's necessarily anything goes. It means that when we're concerned about things like harassment and true threats and the like, we are concerned about the contextual things that make a specific individual or group reasonably and legitimately fearful of things that could happen to them. And I happen to think that's a really hard argument to make when the claim is about what should happen all the way around the world. Last beat on this point, because I think it's an important point. I think most of us would agree that in the wake of the killing of George Floyd, and when there were protests in Cleveland, and there was violence in Cleveland, right? Physical violence, violence, police, property damage, the phrase "no justice, no peace" was fully protected. But all the contextual clues I'm talking about are much closer calls in that context than using "from the river to the sea" in Northeast Ohio. Why? Because because no peace in Cleveland at that time actually meant, laying waste to East 4th Street. And there could be questions about, okay, the people using the phrase, the same people are doing it. That all implicates difficult judgment calls, right? And so we could come up with hypotheticals. Intifada now from Gaza to Ohio. Okay, that would be a closer call under the First Amendment. Why? Because there's a reference to something happening here. Just like things that, again, target a particular individual, target a particular space, right? There's a difference between protesting in front of dorms and protesting on KSL. There's a difference between saying generic things about the administration and saying things about specific people. There's a difference about doing things generally in public and doing things in people's homes. Those sorts of clues matter. But I think that under 208, under the university's 2019 policy, under the First Amendment, a blanket prohibition on the use of that phrase is not sustainable. That's my view. Again, I'm not your lawyer, but I'm not aware of any jurisdiction where that would come out differently.
And I agree. I think that you just look to just start again at Brandenburg, start at even the doctrine of incitement. Start with true threats and what they mean and how they're defined. Under no scenario do I see that phrase being prescribed under those principles at the very least. And then, once again, it does get into the questions or concerns about viewpoint and discrimination based on viewpoint, if it's sought to be enforced. And the opposing views are opposing views similarly prescribed. And if they're not, then why not, right? And so sort of a standalone free blanket policy saying that this statement is outlawed because for whatever reason it's problematic. If it's an incitement or it's a threat, right? It has to be more. It has to be more than that, more than just sort of abstract incitement, abstract threat. And as those cases also make clear and illustrate, Jonathan says there has to be a personalization, more personalization of the statement, or more evidence that immediate action or immediacy of the ability to harm someone or to enact one's goals by the statement has to be.
Maybe one other point I think is important, right? So as we talked about earlier, when we're engaged in protests, there is a separate question, a prudential question about how are we effective. And over the last decade or so, I think there's been a lot of discussion about how when things are potentially offensive, we should be more willing to think about how our audience understands what we say as opposed to how we intend it. And I think in terms of being a member of a community in which we want to respect each other, those are important prudential concerns. And I think it's reasonable for university officials who have no connection to disciplinary proceedings to try and engage people in conversations about thinking through that so the choices about messages and the like are deliberate. But it's important that if that's going to happen, it be people that are not involved in any way with disciplinary proceedings, because it can't be, I'm holding the bat behind my back, you should really be nice to your classmates, right? Because we all understand that there's a power differential there. But if it's someone who, and I don't know enough about the way things are structured in the undergraduate university, precisely who that is, but I can think of the equivalents in this building, right? There are people that have authority and could make a student's life difficult, and there are people that are there to kind of help students work through things. If people in the latter group, it'd be perfectly responsible and reasonable to engage groups and say, hey, look, there are a lot of people who hear that phrase, and with some justification, we'll see it as having these sinister connotations. And maybe that's okay because it gets more attention, but maybe that turns off people that you want to be in dialogue with because they are a member of the same community as you, and maybe you should think about that, right? So that's important too. I really worry when we try and use disciplinary processes and rules to try and force that sort of civility, because that never ends well. But I think that's an important part of this. And I should say, and for those of you that don't know, right, and you may know this, right, I'm not at all sympathetic to the message, and I've also been someone who's been doxxed, has had my family doxxed, has had my family harassed over speech and stuff, and I've had folks come after my job over speech. So I get the feeling things are really touchy and edgy, and there are lines that when they're crossed need to be dealt with. But the principle that your right to, or whomever, this is all hypothetical, that someone's right to express this message that some members of this community find really offensive is as important as the counter message. That's essential to who we are and is a necessary predicate to there being conversations that might result in some sort of accommodation and mutual understanding. And I worry a lot that the university's efforts to tone police protests and things like that get in the way of that ever happening.
And I'm sorry, I think there's one more thing important to add in terms of response to that question. First, my disclaimer too, there's nothing acceptable I found about in that hardest context, and less these charitable context of the use of that phrase that I find acceptable. Jonathan brought to mind heckler's veto. One of the dividing concerns, I think one of the concerns about maybe this over concern about certain types of speech is the campus institution might be worried about the reaction that engenders from the viewer or the listener, or someone who witnesses it or sees it, right? And as legal doctrine has this as the heckler's veto, and the principle is that when a speaker is speaking something that's difficult, something that's offensive, and even deeply offensive, first rule is to protect the speaker, protect the importance of the speaker being able to get their message out before an authority or official pulls the speech or suppresses the speech because they're worried about the way in which the audience might react to it. And so that's been a pretty firm principle there that urges against that reaction or that instinct to automatically censor, if you will, or shortcut or suppress certain topics. One last question, yes.
Can a university or college regulate a silent protest? An example might be a group that just crowds, let's say this venue, with their members, or maybe it's just one person wearing a costume that would identify them in a certain way.
So the standard, if you're talking about the First Amendment standard, and so we're assuming a university is applying that, the relevant standard is going to be disruption of the university's ability to engage in its normal operations. It's not, and so how loud something is one way to disrupt, but blocking ordinary operations, preventing people from getting in and out of a building, blocking walkways, holding up signs so that people can't see a speaker are all silent ways of obstructing university operations. So the loudness is not a necessary component. The question is it inhibiting the ability of the university to engage in its normal functioning? And then ABA Standard 208 makes very explicit that in the context of expressive activities, things that suppress expressive activities by definition do that, right? So university or some university group invites a speaker, people block the doors so people can't get into the room or hold up signs or whatever. Under Standard 208, the law school would be obligated to take action to prevent that from happening. And if you in the free expression policy adopted in 2019, there is a line that expressly refers to that sort of thing. But again, the issue is disruption of ordinary operation, not any particular dimension along which that occurs. And I think we got to stop. Was where it says.
All right.